Petition 10, my lord.
10.
My lord.
You are petitioner?
I'm petitioner, my lord. In person.
Okay, petitioner in person. Okay, the other petitions? Mr. Hussain, can you please come to the mic, please? जी
मोहम्मद सैन चोटिया साहब लाहौर से वो नहीं आ सके, उन्होंने आना था। मैं AOR हूँ।
इसका मतलब क्या हुआ?
एडवोकेट ऑन रिकॉर्ड हूँ, तो मैं
भाई आ नहीं सके का मतलब क्या है? क्यों नहीं आ सके?
उन्होंने आना था, मुझे नहीं पता। मैं तो मैडम ने कहा कि आप
CP नंबर
8
आप बहस करेंगी या नहीं करेंगी या अडॉप्ट करेंगी आर्गुमेंट्स?
जी अडॉप्ट।
कोई पिटिशन रह गए?
From Lahore, I think he's appearing from Lahore.
19 में नहीं है कोई? अच्छा, CP 19 में, ठीक है। ख्वाजा साहब, we don't want to cut you short, but if you can be more precise, just appreciate that some of us have heard this matter and some of us are going to hear it for the first time. There was a question, because since the bench no longer, one member of the bench has retired, to reconstitute it. The question had also arisen whether I should be part of the bench. The related question would arise, should the other two members be part of the bench, because one way or the other our interests, maybe said our interests are affected. Then the related question arose whether all those who, inshallah, become Chief Justice, should they be part of the bench? Should their two senior judges be part of the bench? So I think the best way to resolve it was to constitute a full court, if you agree. And there are also requests in, I think, 3 CMAs for full court. So that is the reason why the full court has, all the judges have convened.
Frankly speaking, let me be very clear. Why did I file this petition?
No. We will come to your petition.
I'm fully, we are with you, sir. The full court should be there.
Achha, so since there are CMA number 4207 has been filed by Pakistan Bar Council, who represents Pakistan Bar Council? So they had sought full court, and there are 2 more CMAs, CMA 3166 and 3199. They had also sought full court. So these applications have become in a way allowed. Okay? So now we proceed to hear your contentions. The rest of you can take a seat. Khawaja Saab will first address, and then the others can address.
I'll hand it over to Mr. Imtiaz Siddiqui, sir, because he's, to be very honest, sir, at the time of the, when this was first heard by 8 judges, Mr. Imtiaz Siddiqui led the arguments. He's fully prepared, but I would like to say a few words.
Let's forget the past. Today is the first date of hearing.
I'll say a few words, and then I'll leave the floor to Mr. Imtiaz Siddiqui. I want to make it one thing very clear. When this Supreme Court Practice and Procedure Act came into force, or became in the form of a bill and later became an act, I read clauses 1 and 2 thereof. Your lords have this act in front of you?
I think one of the petitioners has filed it. It's CMA 5104. I don't know who is 5104. Attached with it. Please read it. Argue as you please.
By the end of your lordship,
which is the petition that you?
I will be starting from 6, sir, because 6 is the one when the orders have been passed. But may I also say?
No, you started with the Practice and Procedure Act. You wanted to read it.
I'll read it. But before I do that, there is an order dated 2nd of May.
Ajay sir,
let's forget about the past.
Because we are not, don't do this.
Okay, so I'll say, let's bury the past.
Don't bury it. It's past. You can't bury the past.
All right. For the time being,
argue as if you are arguing for the first time.
For the first time.
Thank you.
Well, I do say here.
I may ask a question. Khwaja Saab, idhar dekhen. You have endorsed the sitting of the full court, which is fine. But I'm just wondering what will happen to Section 5 in the event if the law is upheld. There is a right of appeal that is provided under this law. In that case, then how do you visualize that right being exercised?
I was going to come to that. I'm very thankful to leadership because if the full court is going to hear it, then I have no right of appeal.
But in the event, since we are hearing the vagaries of this law, what will happen to this right if a full court is now going to proceed with the matter?
In fact, when I go through the law, there are so many things.
वो अपनी जगह है ना जी. Let's just assume बहस हो जाएगी. Section 5 को फिर क्या होगा? Will Section 5 not be exercised by one party?
But it says that an appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution.
Faez Sahab, if I may interject, you please proceed as you want to. Let's read the Act together. Whatever you want to comment about the Act, and please also address the query that has been addressed to you in your own manner as you wish. So let's start with the Act at least.
I would like to answer that when I'm going through this because this is a.
So let's start reading the Act. You want to read the Act or you don't want to read the Act?
I will read the Act now.
Chale,
I'll start with Section 1. But first of all, let me say this one. I would just state this thing that by the end of your honest tenure, if I'm still alive, I would have completed 50 years of practice in this honorable court.
Can you please read? No, let's not do that.
Let me say.
This is public time.
When I saw this act,
let's read it. When you saw it, we're not interested.
Well, see the Section 2 thereof.
Please read the whole Act.
I read it, sir. Whereas Article 191, I'm reading the preamble, 191 of the Constitution provides that subject to the Constitution and law, the Supreme Court may make rules regulating the practice and procedure of the Supreme Court. Now, at present, there are the 1980 rules which govern the procedure here in the Supreme Court. Before that, there were the 1956 rules. The 1980 rules were on account of a judgment which came in 1979.
Ajay Saab, please focus.
Okay, I'm focusing myself.
We know of the 1980 rules.
Background.
No, please don't. We don't. The country expects 57,000 cases to be decided. We would love to hear you, but let's focus on your petition. Now you have started reading, you started giving the history of 1980 rules. We know that. If he'll ask a question, please answer that, but proceed with your arguments.
I have said about this 1980 rules for the simple reason that if I read now Section 2, it says...
Please continue, don't jump to Section 2.
All right. And whereas Article 10A is of the Constitution, mandated right to fair trial and due process. Article 4 of the Constitution guarantees treatment in accordance with law. Article 25 of the Constitution prohibits discriminatory treatment, and right of appeal is a universal fundamental principle of jurisprudence, and Islam guarantees right of appeal. Therefore, pursuant of Article 175(2), read with Article 191 of the Constitution, this law is being enacted. The court will see that there is no mention of item 55 of the federal legislative list as far as this preamble is concerned. It is silent. Because that is the basic, what can the parliament do? Parliament is not omnipotent. It has to go according to certain constitutional limitations. That principle of old principle that the parliament is supreme means that they are omnipotent, led by Dicey and influenced by Blackstone and Co.
Ajay Saab,
over
Ajay
Titanic.
Saab, this-
So
no,
we all agree that
no.
Parliament has limitations.
Bhai Saab, this law doesn't say that. Don't insert words which are not written there. Law doesn't say Parliament is omnipotent. Just restrict yourself to the act which you have challenged.
When I say this thing, that this very preamble does not mention.
It's noted, read it
okay,
on.
Okay. And whereas it is expedient to make a law providing for certain practice and procedures of the Supreme Court. It is hereby enacted as follows. This act shall be called the Supreme Court Practice and Procedure Act 2023, and it shall come into force at once. Constitution of benches, that the crucial question which arose. Every cause, appeal, or matter before the Supreme Court shall be heard and disposed of by a bench constituted by the committee comprising the Chief Justice of Pakistan and two next most senior judges in order of seniority. Now, one of the 1980 rules, Order 11, read in this manner. So if you have to correlate, it may be important to do that.
पहले अगर एक्ट को पढ़ लें हम ताकि हम
मैं
सबको पता लग जाए कि इसमें क्या है
If your lordship,
क्या नहीं
if they,
Sir, which rule were you referring
if
to?
if you want to continue like this, we'll go ahead. But my viewpoint is this, that this frame of these rules under Article 191 is the prerogative of the Supreme Court, sitting as a full court. When they framed the 1980 rules, the entire court sat together and in their wisdom, together they framed the rules. This abdication or this intrusion by the Parliament into the affairs of the Supreme Court prompted me to come forward and file this petition. Because I feel that every institution must remain within its own domain.
Khwaja Sahab, I'm here on this side. Right here. I'm here on this side. If you could kindly formulate your exact legal proposition. What you are suggesting is that you do not have any objection to the untrammeled, unaccountable powers in one office? Is that your question?
My contention is this.
Are you supporting what has happened in the past?
I am supporting what happened in 1980, and I'm
So
supporting.
what is your legal proposition?
My legal proposition is this, that this power of forming the benches, etc., is the domain of the Supreme Court itself.
If this is your
This
proposition.
is my
I think you should read the law first, Khwaja
if this
Sahab,
is-
and then formulate
let us-
the points.
Let us first formulate.
Act पढ़ लीजिए उसके बाद
फिर एक को
It is only
Then
2 pages act. It is only
Let me follow the Chief Justice.
Khwaja Sahab,
Let me read the law,
Khwaja
and then
Sahab,
we make my submission.
If I may make your job easier, undoubtedly, it's sometimes very difficult and disconcerting if
I know it's very difficult to get the answer questions.
Zara sun lijiye, Hazur. If you are receiving a lot of questions from different sides, you don't even know who is asking the questions. If one of your associates jots the questions down, please don't respond to it. We let you argue it as you want to. Let me just finish. You read the act. You just point out, either you say this entire act is ultra vires a constitution, that's one contention. If there are certain particular portions of the act which you think are ultra vires a constitution, please, as you're arguing, point that, formulate the contention and move ahead. You don't need to respond to every query immediately. It will make your life very difficult because you won't even know where the question is coming from. One of your associates can take, and when you're done with your arguments, you can absorb the questions and respond. We will give you time to respond to the queries. ठीक है? तो अब आप please continue with the act.
Second part of this section 2, soon after commencement of this act, the committee constituted under subsection 1 shall hold its first meeting to determine its procedure, including the holding meetings and constitution of benches, provided that till such time the procedure is determined under this subsection, the meeting of the committee for the purposes of subsection 1 shall be convened by the Chief Justice or other two members of the committee as the case may be. The decisions of the committee shall be by majority. Now, this is what the Parliament has enacted. And the provision which they have used is Article 191. At this stage, I would simply say this thing, that when myself and Imtiaz will be answering your question and promulgating, we would certainly refer to item 55 of the federal legislative list, which spells out whether the Parliament can make enactments relating to Supreme Court. If I may read 55 at this stage, it may be.
Argue as you want.
Well, all right, I'm just saying that your Lordship should note item 55 of the federal legislative list.
Let's read it together. You wanted to read it, let's read it.
We'll read it together.
Khwaja Sahab, I think before going, I'm here, left side, your right side. Before going to this entry, if you want, you may read Article 191 of the Constitution. What is said?
191 also. In fact, I can start with Article 70, go on to 142, and then read 191 and go up to 55. Article 70 gives the power of legislation, and it is to the effect legislative procedure. And what it says is, a bill with respect to any matter in the federal legislative list may originate. I will skip that. I'll go straight on to subclause 4 of Article 70. In this article and the succeeding provisions of the Constitution, federal legislative list means the federal legislative list in the 4th schedule. Then there is Article 141. Subject to the Constitution, Majlis and Shura Parliament may make laws, including the laws having extraterritorial operation for the whole or any part of Pakistan, and the Provincial Assembly may make laws for the province or any part thereof. 142. Subject to the Constitution, Majlis and Shura shall have exclusive powers to make laws with respect to any matter in the federal legislative list. Then I take your Lordship 191. To the effect subject to the Constitution, again, subject to the Constitution and law. It is the Supreme Court. The Supreme Court may make rules regulating the practice and procedure of the court. The crucial words here are that the power has been given to the Supreme Court to regulate its practice and procedure.
Your right side. These powers are under the Constitution and the law.
Constitution and the law. I'll say also, I'll come to that also. Because when I read 55, then it will be clearer.
Khwaja, if I may request my learned brother, I know it's very disconcerting, so many judges asking questions. So we will let you argue in your own way, and we will ask you questions. You don't respond, you just note it. And because then I know your chain of thought will...
Point is noted.
Chain of thought we don't want to break.
Constitution and law. Point is noted. Constitution and law. Point is noted of my Lord that what will be my proposition, and also what Justice Mansoor Ali Shah has said, that how will I go and make my propositions, and to say how this law is not obtainable. But may I read 55 at this stage?
Please do.
because your Lordship may ask questions on that. 55 of the Federal Legislative list says about jurisdiction and powers of all courts can be subject to the power of the Parliament under 142 and 74.
Khalid Sahab, just read it as is, don't interpret it. Then you can interpret it.
Okay, I'll go along with that. Jurisdiction and powers of all courts except the Supreme Court with respect to any of the matters in this list and to such extent as is expressly authorized by or under the Constitution.
पाकिस्तान में तारीख साज दिन पहली बार अदालती कार्रवाई बराह रास्त नशर चीफ जस्टिस काजी फायज की सरबराही में प्रैक्टिस है। चीफ जस्टिस की सरबराही में फुल कोर्ट इजलास ने प्रैक्टिस एंड प्रोसीजर एक्ट की कार्रवाई बराह रास्त दिखाने की इजाज़त दी थी। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर कार्रवाई की बराह रास्त इस वक्त नशर की जा रही है। चीफ जस्टिस की सरबराही में 15 रुकनी फुल कोर्ट बेंच इस वक्त तश्कील दिया गया जो बराह रास्त समात को नशर भी कर रहा है। सुप्रीम कोर्ट से ये कवरेज आपको दिखा रहे हैं जहाँ पे चीफ जस्टिस काजी फायज ईसा की सरबराही में फुल कोर्ट बेंच प्रैक्टिस एंड प्रोसीजर केस की समात कर रहा है। ताख़ीर के लिए माजरत खा हूँ, चीफ जस्टिस काजी फायज ईसा की जानिब से ये रिमार्क सामने आए, हम फुल कोर्ट इजलास में थे।
That we have to have jurisdiction and powers both. We'll explain both. This is what the Constitution says. Now, this is regarding the benches, Section 2. In one word, I would say this, that this power of 191 gives the power to the Supreme Court itself to regulate its procedure, as has been done in the past, as has been held in a number of cases which we bring before your Lordship. Those cases are well known.
Now I just ask a question. You can note it. Are you suggesting that that even the rules of 1980 are ultra vires the Constitution? Please let me finish. Because the power vests in the Supreme Court as all the judges of the Supreme Court. That could be one reading of your argument. So you are saying that Section 2 is the ultra vires of the Constitution, which gave power to 3 persons. Order 11 of the rules is ultra vires because it gave power to 1 person. Is that your proposition?
No, my Lord. My proposition is very straightforward. As far as the 1980 rules were concerned, they were made by a full court which was at that time. The entire historical perspective has been given. My proposition is slightly different. These were under 191. It is a function of the Supreme Court itself. They were made by a full court which was at that time. The entire historical perspective has been given. My proposition is slightly different. These were under 191. It is a function of the Supreme Court itself to regulate it.
Okay.
See, Your Majesty, 184.3 is not the only part.
Baja Sahab, you can later you are interpreting it.
I'll answer that. We'll answer that. We noted and we'll answer this thing. But my basic question, why I came before your Lordship, is that the functions which are there with the Supreme Court, there should not have been there. Because that institution that has its own. Today they say that how you are going to have the benches. Tomorrow they will say that such and such bench will hear this case, such and such bench will hear that case.
Please let's not go into what they may or may not do.
Why I'm saying is this, that if I give them unbridled power, then anything can happen. But I will say this thing.
No. what Parliament decides to do future, you can bring another petition, we can look at it then. Restrict yourself to your case. Please proceed.
I will say this in the end, Madam, that this too is beyond the powers of the. There are different types of jurisdiction which are available to you.
Shall we finish with the act quickly?
Okay, I'll finish with that. Exercise of original jurisdiction of the Supreme Court. Any matter invoking exercise of original jurisdiction under Clause 3 of Article 184 of the Constitution shall be first placed before the committee constituted under Section 2 for examination, and if the committee is of the view that a question of public importance with reference to enforcement of any of the fundamental rights conferred by it shall constitute a bench comprising not less than 3 judges of the Supreme Court of Pakistan, which may also include the members of the committee for adjudication of the matter. I will simply say on this thing that this is
not as much right as previously.
yes, my lord.
Over here. This power that Section 3 purports to confer on the committee with regard to examine the question and therefore act as a gateway perhaps, is this a power or is this a judicial power or is this an administrative / statutory power? Because 183 is ultimately a judicial power. Because then it seems to me that the latter part of this section says it shall constitute a bench. That seems to imply that the power exercised by the committee is not a judicial power but an administrative power. So can Parliament whittle down? This is a question, please note.
Yes, it's
Whittle
judicial,
down the
and in fact, that is
whittle down- Can the Parliament whittle down the judicial power under 184(3) by providing that this committee will act as a gateway and block out in exercise of administrative power anything that the committee feels, 3 judges, not the whole of the Supreme Court, but 3 judges. But in the end, just 3 judges block out any case that they, in exercise of administrative power, they will deprive the Supreme Court from exercising judicial power. Kindly note the question and you address it.
I will go even further than that, Madam.
And also a supplemental connected to this. Earlier, the justice solely had this power. So there was a likelihood that the outcome of the cases could also have been influenced by the constitution of the bench. So that eroded the independence of judiciary. If this argument is accepted, then the earlier traditional model would be acceptable to you. That one person can actually control the outcomes of the cases by constitution of benches. And this probably was the mischief that the Parliament wanted to address.
I would,
If I may add, invoke jurisdiction of this court under Article 183. And it says where the bench, 3-member bench, 2-member bench, but a bench comes to the conclusion that there is a matter of
public importance,
Involving
rights,
fundamental rights.
they may recommend after seeing the reasons that the bench has assigned for recommending, he may or may not, but at least he would recall reasons why he thinks he disagrees with the recommendation, or thereafter he can proceed. So there is a judicial pronouncement on that already in place.
In fact,
Ajay Sahab, I'm sorry, since
may I say,
Honorable Chief Justice has said that we can only ask questions and not for you to respond immediately. So let me, with all due respect, ask a supplemental to what my supplemental put to you by my learned brother, colleague Justice Atar Minallah. It seems to me that the power to constitute a bench, which is the subject matter of Section 2, constituting a bench does not block the exercise of judicial power. It simply determines which is the bench that is to exercise judicial power.
yeah.
But my question to you is that Section 3 seems to go beyond that. Section 3 is separate from Section 2. It actually blocks, it confers on the administrative powers, actually block the exercise of judicial power. It's not a question of constitution of benches. They can say, sorry, out, nothing further, matter ends. The question is this. So this is not a question of composition of benches. That is power conferred universally on them in terms of Section 2. The question here, it seems to me, is the very blocking of the judicial power itself. Can Parliament do that? The question is maybe more. You don't have to answer.
I'm not
Please
answering.
carry on.
I'm not answering.
The Honorable Chief Justice has said you carry on with your submissions. Just note the question.
This thing, I will add one thing. Also, the price of my right, which they have said that they are passing this thing under Article 10A of the Constitution. Here, if Section 3 is here, I'm being condemned. Not being heard.
Who is
the
that?
party is not being
Please,
heard.
who is when you're using the word I? Who is the I here?
It was
एक second. The litigant. That leads me to another question. Your petitioners, do they have an interest in the matter, or they've come purely as a matter of public interest? No, I'm not talking that. I'm not asking a question of the petitioners. Do they have an interest in any case why they brought this challenge? In the public interest, what is the answer?
Public interest.
You have no personal interest in the matter, you or your client.
I have no personal interest.
You meaning your client.
But let me say this thing.
Answer to that.
Myself and Mr. Pro bono. We are doing it because we want to know. I don't know who you're speaking for. Are you speaking for counsel? Are you speaking for petitioners? I'm speaking for the petitioner and I'm saying this thing that we brought this petition.
In the interest. You got the answer. Now please proceed. I've got the answer.
In the interest that the law should take its course. The Constitution must be upheld. And I am also saying that I'm sure with such eliminaries sitting there, the whole object is that, first of all, the independence of the judiciary should not be in any manner smeared by any other institution. And secondly,
Qazi Saab, please.
What you are saying is that the untrammeled, unaccountable powers of the Chief Justice exclusively to decide constitution of benches. You were satisfied with that, and that fulfilled the conditions of Article 10A. But if it is done by the Chief Justice and two senior judges, you have an objection to that. That's your proposition.
I've not been able to explain Section 2 stands on its own footing. Section on that. Section 3 is a totally different thing. It takes away the powers. Why it does not, instead of Section 3 is a totally different thing. It takes away the powers of this honorable court. Why it does not, instead of
Is it your argument?
Let us clarify.
Is it your
It
argument
takes
that
away
Section 3 affects the judicial powers of this court?
Yes, sir.
Curtails judicial powers of this court because this justice and all judges. So it confines that power to 3 judges and not to the judges of the Supreme Court.
That's not fine.
I've been trying.
2 and 3 have to be read independently and separate.
Now, please.
There are 2 in exercise of
Yes, sir.
I'm trying to make your life easy, but if you don't want it to be made easy, that's fine. But I mean, please don't interrupt. I've requested you, please keep noting the queries. Naturally, you have a chain of thought, you have submissions. We don't want you to get, I can appreciate your position, so many judges, so many questions, which one do you answer? And then your argument is lost sight of and you go somewhere else. So please persevere with your thing, keep noting the questions, and you can address them. So I'm trying to make your life easy, unless you don't want it to be made easy. So proceed with your case. Respond to it later.
To be very, very honest,
me.
I welcome this for a simple reason.
About the office of the Chief Justice after passing of this act, don't you think that the office of the Chief Justice would become redundant? Because he would be left with no powers then.
We noted this down, and in fact, I will say that the Chief Justice powers will be whittled down. As if this law goes through, the powers will be whittled down, but we'll explain it in something. And this has been held in many places, that the Chief Justice has the power to form the benches, is the rooster, and I can go back years and years when a chain of judgments have come in.
ऐसा फिर आप आंसर करने बैठ गए।
I will continue. Let me
आप नोट
continue.
कर लें, बाद में कर लें।
Let me continue. Then is a question.
Mr. Khwaja,
Yes, sir.
right side.
Right side.
I
Okay.
will add whether power of the Supreme Court has been curtailed or the power of the Chief Justice has been.
I think
That's the moot question.
the answer to that is that it's been noted, sir. It's noted, and I will only say this thing, that Supreme Court, what is Supreme Court? Supreme Court is Chief Justice and so many other judges.
Wajah sir, we'll be sitting here till 12 o'clock.
I know that, sir.
So आप जरा
let's
अपना
go.
argument
I will only say this thing, that this certainly taken away the power not only from the Supreme Court and the judges, but also it has condemned me unheard and violated the provisions of Article 10A. Totally redundant. This is my point. So therefore, to that extent, Section 3 is involved. Committee shall constitute a bench comprising not less than 5 judges of the Supreme Court. Well, I will.
Do you object for say I object to this provision, or you endorse it?
When you are, all the judges are competent to interpret the Constitution. By limiting it to 5 or limiting it to 3 or why not 7?
Yes, sir,
Why not
please,
6?
please.
I
No, you're
I
arguing-
object to this thing.
Would be a full court like the present court. So are you safe? Is this ultra vires the Constitution Section 4? Say something, we should note it.
in less than 5 judges?
Noted.
Because this is very strange because all judges are equal. Your lordship is the first amongst the equal, but every other judge of the Supreme Court has the same powers and the same. So by saying this thing, not less than
आगे बढ़ें,
5.
आगे बढ़ें.
As I
Then there's a
understand,
question of appeal, and which is a very relevant point.
previous model, being the master of the roster, had untrammeled power to constitute a bench of 3 members, and you were satisfied with that. But if a
I have
committee,
noted this thing.
Yes.
Your lordship, sir, I will not be able to explain my shortcoming.
explain later.
On the
answer-
question of benches, should be exercised by the full court, not by the parliament. How the benches are to be
आगे
formed.
बढ़ते हैं.
All of you sitting together feel under 191 that it should be changed, then it is your function. It is not the function of the parliament.
Proceed. We'll ask.
I'll argue on that.
तो आप-
That is the point which needs consideration. Appeal. Yes, Marisa.
It serves me right. Section 4, what is the equivalent of Section 4, article of that Constitution. It was a part of the 1956 Constitution, article of that Constitution. Now, question is that when the framers of the present Constitution had before them this model where this very power was conferred on the Supreme Court in the way that what in India they are called constitution benches. Question is this, that model, that aspect was not accepted by the framers of the present constitution because they had a model both from India and from Pakistan itself. So the question is this, if that was not accepted, does this not require constitutional amendment? Can Parliament do something which the framers of the Constitution deliberately seem to have left out, despite the earlier models? Can Parliament then, in exercise of sub-constitutional jurisdiction, namely legislative competence, do something that was earlier part of the Constitution? This is the question, please note.
Yeah, it's noted, sir, and I may add on to this.
भैया साहब मैं एक सवाल पूछ लूं आपसे, अगर उसी में डाल दें आप लिस्ट में अपनी।
जी
मैं इधर हूँ जी।
जी सर।
भाई बस सिर्फ सिंपल सा आपकी जो समझ आई है मुझे आपकी कि ये सारा कानून अगर यही सारा फुल कोर्ट बैठ के बना ले तो सब ठीक है।
नहीं सर,
सुन लीजिए, सवाल तो सुन लें
जी जी
कि 17 जज बैठ के ये सब कुछ बना ले तो ठीक है, पार्लियामेंट ये सारी चीज बना दे तो गलत है। ये आपकी बहस है ना सारी?
नहीं सर, ऐसे नहीं है।
आपने यही कहा, आपने कहा ये सारी चीजें करो, लेकिन
नहीं सर ऐसे नहीं,
सुप्रीम कोर्ट
नहीं सर ऐसे नहीं है।
चलिए बस नोट कर लीजिए।
मैं नोट कर लिए, जब सुप्रीम कोर्ट एक
आप जवाब ना दीजिए ना, बाद में
मैं बाद में जवाब देता हूं।
ठीक है, अदरवाइज तो आप आपकी मुश्किल काम हो जाएगा।
मैं आई एम क्वाइट आई हैव अ वेरी
नहीं आगे बढ़ते हैं।
I have worked with all of you, sir.
आगे बढ़िए।
I have no problems.
हजूर आगे बढ़िए, आगे बढ़िए।
If I
मुझे
may,
कोई
Khwaja sir,
problem नहीं है. I understand what Shah
if
Sahab
I may.
is suggesting and saying. Yes, I mentioned this in many other cases. Yes, ma'am.
If I may ask to the question that my learned brother, my learned colleague has asked, independence of the judiciary is a recognized fundamental right.
Yes, ma'am.
So the question, surely, this is the question to you, surely the question of what the court can itself do to regulate its own practice and procedure is now in the independence of the judiciary, and can Parliament, upon, with all due respect to Parliament, they have their legislative competence, the Constitution is supreme, that is what is paramount, that is what is there. Can Parliament, in professed exercise of a legislative competence under Article 191 trample upon, I'm using this word a bit deliberately, I don't intend to show any disrespect to Parliament, but can it encroach upon or intrude upon something that would affect the independence of the judiciary, something that relates to practice and procedure, which the court may or may not do, but can do for itself? Can Parliament do that? In other words, when Article 191, this is part of that question, starts with subject to the Constitution, the law part of it is also being subject to the Constitution, and the Constitution says independence of judiciary is a fundamental right. Can Parliament directly or indirectly take away a fundamental right?
आप नोट कर लें जवाब ना दें
If I will really request my colleagues that they are making, including myself, are making your life impossible. No, please, no, you are very fine.
I'm learning.
No, we are not here to teach you anything. You are here to help us. Now, please, we're not even reading the act and we are getting bogged down into details. Let us go through it, formulate your contentions. We will bombard you with 100 questions. You respond to them later. You respond to everything, then the matter gets lost. Again, we are stuck with section. We are not even making progress. Please continue in your way.
आगे बढ़ते हैं. Let me say this. Mr. Khwaja, Khwaja sahab, section 5 से आगे पढ़ लीजिए.
Another question with regard to appeal. आप देखें, हमारे पास already एक dictator का ordinance था, Law Reform Ordinance 1972. उसके तहत Article 199 के लिए appeal provide की गई before 2 member benches. We are following it. क्या वो जो डिक्टेटर का था वो दुरुस्त है और पार्लियामेंट अपील का राइट नहीं दे सकती? बहुत तो अपील का राइट दिया है, सेम प्रोविजन कॉन्स्टिट्यूशन, आर्टिकल 199 है, आर्टिकल 183 84(3). तो ये क्या दोनों में गलत है? तो फिर वो भी गलत.
It is not. We'll answer this thing that what Parliament can do and what Parliament can do many things. My Lord has said so, but there is a procedure provided. Will answer that.
भाई साहब, अभी जो आपकी जरूरत नहीं है, आप प्लीज एक्ट
I will not answer it.
पहले एक्ट को खत्म कर
Section 5 से आप आगे बढ़ लीजिए.
Khwaja sahab,
you have collected 100 questions.
Just here. The Law Reforms Ordinance of
How you will
1972.
answer.
This is the question to you. Regulated right of appeal within the High Court itself, an intra-court appeal. Was there ever a clause on the jurisdiction and on the legislative competence in relation to jurisdiction and powers of the High Court in the same manner as it is in the Supreme Court? As I read it, the clause is there only in respect of the Supreme Court. Law Reforms Ordinance didn't do anything with the Supreme Court. It only affected intra-court appeals within the High Court, both in the concurrent list, which is now no longer there, and also the clause was only in relation to Supreme Court. Question: is therefore the Law Reforms Ordinance of 1972 a parallel valid example which relates only to the High Courts, a valid parallel example in relation to what Parliament seeks now to do in the 2023 Act? This is the question. With relation to the Supreme Court, where there is apparently a clause.
Mr. Noted, sir. And appreciate. Section 5. An appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of Article 184 of the Constitution to a larger bench of the Supreme Court, and such appeal shall, within a period not exceeding 14 days, be fixed for hearing. And second part, the right of appeal under subsection 1 shall also be available to an aggrieved person of this Act, provided that the appeal under this section shall be filed within 30 days of the commencement of this Act. I'm not going to analyze it. I have my serious objection on this, and I will.
So what you have to do, you're saying I'm not going to do it. You have challenged the law, you have to challenge it.
Appeal shall lie within 30 days.
We've read the English of it. What's wrong with it? Tell us that.
as far as Section 5 is concerned.
Is it good, is it bad? First tell us that.
Well, it says that appeal shall lie within 30 days from an order of a bench exercising jurisdiction under Clause 3 of 184. May I respectfully submit that if an appeal is provided against a decision under 184.3, then why is this not they included in Clause 2? Whereby my 184.3 application will be disposed of.
Sir, the way I was taught law was not the council asked questions from the bench. It was the bench would ask questions. Are you supporting this provision or not? First say, yes, I am. No, I am not. These are my reasons.
My lord, I have a reservation on this.
You may have reservations. Tell us constitutional about it.
But then let me explain it to them, because if I start explaining it at this stage, it will take your time. But I will say this thing, that this Section 5 should have also, this right of appeal should also have been given in Section 2.
Should is different from ultra vires a constitution.
It ought to have been given.
What, then you go and move a bill in parliament. We are saying, are you opposed to Section 5? Give us legal reasonings, or you say it's okay. अब उनसे आप पूछेंगे
you have done this.
नहीं ये नहीं आप जवाब दीजिए ना आपने पिटिशन लाए this is not fair.
इसमें to make it more simple, you don't want your client to have a right of appeal.
So, sir, I
first say it's unconstitutional, it's constitutional. You're not saying anything. You just यहाँ कोई discussion होता है. Sorry, not on. This is your job in office.
My lord, may I say this thing that we divided the...
Please answer the question, is this constitutional or unconstitutional?
It is unconstitutional.
I can't hear you.
वायरिस तो बताइए ना, वायरिस क्या है?
Hey, unconstitutional आपके जहन में और नहीं है?
Unconstitutional.
It's my personal opinion is this.
मुल्क की तारीख में पहली बार सुप्रीम कोर्ट की कार्रवाई बराह रास्त नशर की जा रही है और अदालत उज़्मा ने सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर एक्ट के खिलाफ अपीलों पर फुल कोर्ट बनाने की दरख्वास्तें मंजूर कर लीं। सुप्रीम कोर्ट में प्रैक्टिस एंड प्रोसीजर के खिलाफ दरख्वास्तों पर समाअत कर रहे हैं।